parties be allowed to abide by that contract. My client, there were some issues getting the water turned over into his name, mainly because there was an outdue balance on there. My client ended up paying that outdue balance, but that allowed the defendant to cut off the water. And so essentially what we're asking is that she leave him alone, allow him to continue to reside and take over the property, and that he will continue to reside in the property and make the bills pursuant to the agreement. That's the long and the short of it, Judge. And we're asking that she be enjoined from going onto the property, from interrupting his quiet enjoyment, from cutting off any more utilities or trying to move any of her personal effects back onto the property. That's really it in a nutshell.
So what you're asking, at least according to the order that you provided, and maybe this is not all still correct, is a temporary restraining order keeping Ms. Jacobs from shutting off any utility service, entering the property, or harassing the plaintiff, as well as taking all actions to restore the water utility services. That's already been done, as I understand. Is that correct?
Yes, sir. Water service has been restored. And so those 3 bullet points that you put up on the screen, that is what we are asking for. Yes, sir.
So, Ms. Jacobs, you understand what this is about?
Yes, sir. I understand what it's about.
Okay. So do you have any response you'd like to make?
Yes, sir. I feel that without legal representation, due process will not be served. Because I'm not adequately represented. And if it pleases the court, I'd like to ask for continuance until I can be represented by counsel. Your Honor, I can give you my new attorney's name that I would be meeting with on the 21st of next month. The other attorney, I did get a message from him this morning because he was on vacation the week prior. He was off last Tuesday and he does not work Fridays. So last Friday, sir, I could not get a hold of the gentleman. I tried continuously. I did what his office asked me to do, which was send him just in short what was going on. And then I did get a response this morning from him saying that he is not able at this time to take on any more litigation. I don't know the correct terminology, sir, because I don't deal with the courts, but he can't take on any more work at this time, okay? And so I have sought other legal counsel this morning, and I spoke to him and we agreed, and he asked me under certain conditions, and if I was prepared for all this, which I need to be prepared. So yes, I am prepared. So, sir, I'm asking you, because of the time and the time frame, and because of me not knowing anything about this prior to Friday, prior to getting a phone call, prior to just being yanked on the telephone and thrown into something without legal counsel. And I'm asking you, please, I'm begging the courts, I'm begging you to please let me get legal counsel to represent me. Because yes, sir, I was talking with legal counsel last week. And like I said, he wasn't there very many days. And I have sought counsel this morning. And I have an appointment on the 21st, and I can give you that.
So today is the 21st, so you don't have the appointment for another month?
Exactly.
Okay.
And
so let me just kind of explain one thing to you, Mr. A couple things, just so you kind of have a feel for what's kind of going on here. So first off, they're trying to get injunctive release, which means they're trying to stop you from doing something. There are 3 phases of that within Texas law. So the first phase is the temporary restraining order. That would last for only 14 days. The second phase is the temporary injunction. That's much more serious because that would last until the trial setting, which will probably be in about a year to a year and a half. And then the final phase would be at trial, which is the permanent injunction. And so the phase we're at right now is not quite as serious because it's only for 14 days. They're asking for basically 3 things. They're asking that you don't shut off the utilities, that you don't enter the property, and that you don't harass the plaintiff. I don't know enough about I guess you own this property and they're renting the property. Is that right?
I guess you would call it a lease to own, sir.
Okay.
And what I have there is family heirlooms. And what I also have there is what was supposed to stay in the house. He has since then thrown it out into a wooden shed that is not locked. And yes, sir, I left a lock on there. I gave him a key to that shed. I gave him keys to every single thing there. I did not know all this was going to go left. I've known these people my whole entire life, but that's all besides the point. It is what it is now. So, saying all that to say this, the only thing that I've gone over there for, sir, the only thing I've gone is to try to get my stuff. I've only been there 3 times since February, so I have not been harassing this dude. He stole my grandmother's heirlooms, which is a milk glass set, and it's not worth anything to anybody but myself. That's my family heirlooms, and I want my family heirlooms, sir. I want them. And why do I have to wait 1.5 years to get my family heirlooms? There's a drug house across the street. The shed has already been broken into. And I said to him when I was there the last time, he called the cops before I even got there, sir, and said there was a disturbance in the house. In Mesquite, you call the cops, every cop comes. Well, here comes all these cops. The cop jumps out. He can't even get out of his car and undo his seatbelt fast enough. He's looking for a disturbance. There's no disturbance because Les Redmond isn't there. But when Les Redmond got there, he jumped out and attacked me, started telling me he was going to lean my house. His exact words, he was going to pack his shit and get the fuck out of that house. That's what he told me, sir. I have him saying that multiple times. I have him in text and I have it in other forms. I have not done anything to this gentleman. There's no reason for them to want to keep my family heirlooms. That's the only thing I want from there. Those dope heads have already broke in there. Somebody took the bicycle, and it's a trick bicycle, and it was worth a lot of money. Now, I said something to Mr. Les about that when I was there about 3 Saturdays at most ago. And I said, Les, it's already gotten broke into. And he says, so? So, see, my stuff means
So,
nothing.
Miss Jacobs, let me just ask this.
Yes,
so,
sir.
Because I want to make sure I understand fully your position. So you would like to be able to go on the property and get your heirlooms, is that right?
Yes, sir. Yes, sir. Please.
So, and those are all in the shed or some of them are in the house?
I don't know where that guy's put all of it. I think he did put everything that I had in that shed, which it was not supposed to be. I even told him, I said, Les, it's hot outside. I have stuff in there that's probably melting.
So let me ask this.
Yes, sir.
How much stuff is there? Is there enough?
You won't let me look.
I mean, you know what was there before, right?
I know that I have my collection. I know I have a large Craftsman, those things that men put their tools in, like it's in a machine shop. Yeah, I have a shed full. So yeah, it's a U-Haul. I don't know what size U-Haul, but I'll take one U-Haul and I'll make it one trip. I promise.
Mr. Carpenter, you're the attorney, right?
Yes, sir.
I mean, it doesn't seem unreasonable for her to be able to go and get her stuff.
And I'm happy to work that out, Judge. She has not made that request through us at all. I'm happy to facilitate that at any time.
So what if we did this? This is just a suggestion, and we can kind of talk through it. Is what if we include in the order that you have the right to enter the property? So there's a couple issues here. One is, since you own the property, I do want you to be able to go to the property if there's a need to for some other reason. I can't imagine what that would be, but for whatever
No,
reason,
sir.
So we would keep you from shutting off the utility services without permission of the court. So you need to add that, Mr. Carpenter. So let's say, for example, they stop paying the utilities, then Ms. Jacobs should be able to shut them off, but you would need to get my permission to do that. You'd be able to enter the property once to retrieve your personal property, which would be all your heirlooms, and you'll coordinate that with Mr. Carpenter, and then you won't harass the plaintiff. It doesn't sound like you are harassing the plaintiff.
No, sir.
But you won't do that. How does that sound, Miss Jacobs?
That sounds mighty fine with me. And in the meantime, I can get my legal counsel and I'll have time to get my stuff. That's what I'm asking you for today, please.
All right, so we're going to go ahead and enter the TRO, just like I said. So you'll have an opportunity to go to the property. If you do need to shut off the utilities, you need to request my permission. If you need to enter the property again, you'll need to ask my permission.
Yes,
You're
sir.
not allowed to harass the plaintiff.
Yes, sir.
Under the rules, I have to set this for hearing in 2 weeks. We can extend that, and I would encourage you to. I mean, I'm perfectly okay with extending if the parties agree to extend it till after you have a chance to talk to this other attorney. But for now, we'll need to go ahead and reset this in 2 weeks.
Okay. May I ask a question, please, sir?
Sure.
Okay. And why would y'all go ahead without legal counsel? I mean,
so let me explain one thing. There's something a lot of people don't realize is that in the criminal system, you have a right to counsel. So let's say you were being charged with a criminal offense.
Yes, sir.
As a judge, I'd be required to appoint you an attorney.
Yes, sir.
In the civil system, there is no requirement and you can represent yourself. And in fact, I don't have any funds to appoint an attorney for you. So we're trying to come up with kind of a win-win solution here.
Yes, sir.
To give you time, you could extend. It doesn't sound like you have a big problem with the terms of this TRO because you'll be able to get your property. You don't really want to go on the property anyway. You're not going to shut off the utilities in the next month. It doesn't sound like.
No,
you have an out where you can do it, but there is no right to counsel in a civil case, and this is a civil case. Does that explain that?
Yes, sir. It doesn't sound right, but you know what sounds right to me never is.
Yeah, that's so, I can tell you I've had other cases like this where I feel terrible. But I just don't even have funds to appoint you an attorney.
That's fine. That's fine.
So
if I don't have one, I'm just gonna have to represent myself, or at that time, could I please ask for a continuance? Or
So let me just explain how this works. That's a very good question. So I have to set this within 14 days. That's required by the rules.
Yes, sir.
And then we'll set it for the temporary injunction. The temporary injunction is the big hearing that you really need to be concerned about. Although you might be able to work out a deal with Mr. Carpenter, you don't need to do this. But if we're going to, that has to be set within 2 weeks. You can agree to extend this as many times as you want and for as long as you want. It doesn't matter to me if both sides agree.
Yes, sir.
If both sides don't agree, then I can extend it another 2 weeks. That's how the rules work.
Yes, sir.
You agree and you say to Mr. Carpenter, hey, I need another month or 2 months to get an attorney. I would guess Mr. Carpenter would agree as long as the temporary restraining order stays in place.
Okay.
That makes sense.
Yes, sir. All I ever wanted, I've known Mr. Redmond since he was 2 years old, if not before. I've known his mama her whole entire life, 60 years. We're mutual cousins to cousins. And I didn't want anything anymore than to have this young man to have and be able to own a home. That's how this all started, sir. It was all in good faith. And I have not received rent from this gentleman. And when he did send, he sent $301. He sent what he thought I deserved. And it also cost me $35, I believe it was, sir, to accept the money through a Zilly or something. Well, I'm not doing that. Okay. And also, if they read the bottom of that contract, we're going to be stuck with the contract, it says that he will mail a check by the 1st of each month. And he has not done that, sir. And if he paid that water, I'm not too sure about him paying that water because that water was going to be my final bill. That's the water he left out there for them dope heads to go over there and run all their gallons. So yes, the water got turned off, and it was going to get turned off in like 2 days anyway because of non-payment. Why, sir? I have no
So Ms. Jacobs, let
unemployment.
me just say this. I have other hearings I've got to get to.
Yes, sir.
So all of this stuff that you're telling me now would be really good to bring up during the temporary injunction hearing if we end up having
Okay.
one.
Okay.
For right now, we're going to go ahead and enter the temporary restraining order. You need to comply with what I've said, which is if you want to shut off the utilities, you got to get my permission. You want to enter the property, you need to coordinate with Mr. Carpenter to get all your stuff. If you want to enter it again, you need to get permission from me, and you need to not harass him, which doesn't sound like you're doing. We're going to have a hearing in 2 weeks unless you guys agree to extend it. And Mr. Carpenter, I'd strongly urge you to agree to that. We're going to set this on October 5th at 3 o'clock. So you would be nice if you had an attorney by that, but we are glad to extend that to some later date to give you a chance to have an attorney.
Yes, sir.
And the only other thing is that you are required, Mr. Carpenter, your client is required to post a bond. And I'm not going to waive that. So you're going to need to post a $100 bond, Mr. Carpenter, on behalf of your client.
Yes, sir.
Ms. Jacobs, you do not need to post a bond.
Okay.
So
now, can you please explain to me just one more time? I know that you have other people and probably more important things. A temporary conjunction, sir. Could you explain to me one more time? What is that, please?
temporary injunction is they're going to ask to make permanent what we're doing here today, or not permanent, that to put into place the protections we're putting in right now, to
Yes,
put those
sir.
in place through trial. So, and the trial would be in a year and a half. So they're going to be asking to extend this TRO essentially until trial. Right now, it's only good for 2 weeks unless you extend it or I extend it.
Okay.
They're going to ask to extend it until trial.
Yes, sir. Okay.
Now,
And
I will
Go
say
ahead.
this, that in many, many cases, the parties reach an agreement about this. And you never have to have a temporary injunction hearing. So you might want to talk to your attorney or Mr. Carpenter, see if you guys can work something out where you can just
Right.
agree to the form of this.
Yes, sir. Well, like I told you a while ago, it was all in good faith, and I didn't want nothing any more than for that boy to be able to own a home because he didn't pay his stuff for going to school, so he can't get a loan. He
Okay.
can't get nothing. So I was going to do it and not charge him any interest, which would have probably cost him 75,000. And I was in good faith doing this so that this young man could own a home.
Ms.
And
Jacobs,
yes, sir.
it sounds
I
like you're
know.
trying to do a good thing, and
Yes, sir.
but right now that's not what we're talking about.
Okay.
So we'll
Can I
talk
ask-
about that at the injunction.
Okay.
And so
One
this is your
question.
last question. I really
Yes,
got to
sir.
get to the next thing.
Yes, sir. He should still be paying me rent. Is that correct?
And that's I don't know one way or the other because that hasn't been brought up to me. So you could countersue him to evict him or to require him to pay rent or whatever. All this is about is whether or not you have a right to enter the property or shut off the
Okay.
water. And so that's not
Yes,
what
sir.
we're talking about. So right
Yes,
now.
sir. Okay.
Thank you,
I
Ms.
got you.
Jacobs.
Thank
Mr.
you,
Carpenter,
Chris.
make sure you get me a form of this order as I just discussed. Make sure you e-file it, send it to Ms. Jacobs, and email my court coordinator, Rhonda Pinson.
Yes, sir. Over the
Thank
And
you,
I called-
guys. You have a
I
good
called
day.
Mr. Despain myself. Is that right? And try to make
Yeah,
try
or
to make
yeah, Mr.
arrangements for
Despain,
going
or
over there.
do you work for Mr. Despain, Mr. Carpenter?
He works for me, Judge.
Okay. So can you give Ms. Jacobs your phone number so she can call you?
Yes, sir. Do you want me to do it now or?
Yeah, please.
It's 972
You can write this down, Ms. Jacobs.
Yes, sir.
455-8700.
And Judge Hoffman, could I please get your phone number? Because you said to contact you if anything.
Yeah, 214-653-6510.
Thank you, sir. Have a great day.
You guys have a great day.
Thank you, Judge.
Thank you. All right. Bye-bye.
anything. Okay. All right, need to go to the next hearing now. Okay. All right, what's next here? So do we have Narina Properties versus Veterinarian Specialist of North Texas?
Yes, Your Honor. Cheryl Mann here on behalf of defendant Glenn King.
Deborah Edmondson on behalf of the plaintiff, Narina Properties LP.
Okay, you guys want a record on this?
Yes, please.
All right, Tony, let's go on the record on cause number 203033, Narina Properties LP versus Veterinarian Specialist of North Texas PLLC et al. Counsel, make your appearance.
Listen on these courts.
Cheryl Mann, counsel for Dr. Glenn King, defendant.
Deborah Edmondson, counsel for Narina Properties LP plaintiff.
All right, so I've read the motion for summary judgment and the response and the reply and the objections. It seems fairly clear to me at this point, this really needs to be governed by just what was signed, and it doesn't seem like there was an individual that Mr. King individually guaranteed either of these leases. So I guess we kind of start from there.
Your Honor, thank you, Cheryl Mann, for the defendant movement, Dr. Glenn King. I'm not really sure I need to add much else because it sounds like Your Honor has read my papers and has the same position that my client does on these papers. I don't really have anything to add.
Why don't we do this? We'll hear from opposing counsel, and then if they bring up something that I find at all persuasive, I'll have you respond.
Thank you, Your Honor.
And I'll point out to the interns, that's really good lawyering by Miss Mann. When you're winning, you don't talk your way out of it. So, Miss Edmondson, why don't you respond?
Well, first of all, it is governed by the 4 pages pursuant to the fact that there's no argument that VSNT, which is Veterinary Specialists of North Texas, signed the first lease agreement. The decision needs to be made. The court has to construe the first lease agreement. So if you look at the 2 signatures, first of all, if you read the lease, the tenant is described as Veterinary Specialists of North Texas PLLC. The guarantor is described as Texas Gulf Coast Veterinary Specialists PLLC. The guarantor is Dr. King signed the lease as Dr. King, and this is in my argument, Dr. King, DBM, and then he put member Veterinary Specialists of North Texas. When he signed the guarantee, the personal guarantee, he signed as Dr. Glenn King, DVN. He wrote underneath Texas Veterinary Specialists of North Texas. However, he didn't indicate anything else, whether he was a member or anything. I've cited a case in my paper, which is
Why don't you share screen exactly how he signed it, Miss Edmondson?
Yes, okay. Do I? Okay, just.
You should have permission to share.
Okay, well,
I'll stop share just so you.
Okay, sorry, it's gonna take me a minute or 2 to do this.
I've enabled it so you can.
All right, so we're gonna share.
Or if it'd be quicker, okay, you sound like you're doing it.
Well, I'm trying to get to the document. That's the trick in this, okay?
Your Honor, it's page 26 of my appendix. If Your Honor has the file up.
I I don't. I could
Is
get
this,
it.
I mean, I'm trying to screen share. Says,
You are screen sharing.
is there a document up there?
No, we can see your background, which is a lady jogging with on the beach.
Really? I don't know what that is, but
But now we have something else that says Marina Properties, but you need to
well,
move
I'm
down.
trying, okay, here we go. This is it. Okay. Can you see this?
Yeah. There's an
Okay.
affidavit.
All right, so that's closer to the end here, sorry. All right, so here is in 3.7, and I've noted this on the paper, wherever there is a square bracket, that is something that was filled in with handwriting, okay?
Okay.
So it says Dr. King signed, oh, let me back up. Go up, I'm sorry, let's go up to 3.5. So he signed the first lease agreement as executed by tenant, and again, wherever there's brackets, that is something that was handwritten. So first day of Jan 2016. Then he signs his name DVM with a title, and he signs the EIN, no security, okay? Now there's a space just below that for a guarantor to sign on the lease, which I'll pull up the lease in a minute. That's not signed. Then you go to Exhibit G of the guarantee, which states to induce Marina Properties to execute the lease with the tenant, okay, for the premises and blah, blah, blah. Okay, it is agreed that the undersigned, and this is in the guarantee, shall be primary and not secondary, as if the undersigned has executed the lease as tenant. So in other words, our argument is there's an anticipation that the guarantor and the tenant will be different. Dr. King signed the guarantee as follows. And again, the bracketed is where it's handwriting. So executed this first day, guarantors, and then there's crossed out and it's handwritten over the crossed out name, that there's a handwritten cross out. And then veterinary specialist of North Texas, there's an address, and that's it, okay? So then if we go down to, and I can pull that up in the actual lease to show you. Okay, so this is the lease. This is what we call the first lease agreement, and you can see the date is 1/1/2016.
Okay.
And here's tenant is defined there.
Mm-hmm.
And then guarantor is defined here
Well, let me see. Where does it say the guarantor?
under S.
So the guarantor is Texas Gulf Coast Veterinarian Specialist. Okay.
Okay.
That's not Mr. King, right?
Well, that's what's written in the lease and not changed.
Okay.
So then, you know, I'm going through the lease quickly to get to the guarantee, which is Exhibit G. All right, so here's the signature. This is the last paragraph of the lease, 28.28, okay? And then here it's executed by landlord. The landlord is Narina Properties. It's signed by Tazim Hashim. And then comma, there's a title there, General Partners. And then executed by tenant Veterinary Specialists of North Texas. Then Glenn K. King, DVM. There's a title, member, and then a tax ID. Okay, then under guarantor, it's crossed out.
Oh,
Okay,
so
but-
Mr. King never signs, no one ever signs the guarantee?
Well, no, this is the lease. We go to we're gonna go down one page further on this,
Okay.
okay? Or not one page, but we're gonna get into the exhibits.
Okay.
Okay, so now we're at Exhibit G, guarantee. So then
Okay.
it says, to induce Narina Properties LP landlord to execute the lease agreement with veterinary specialists. And there's a typo there. It says January 1, it meant 2016 for certain demised premises. And then it goes on, okay? And it talks about the undersigned agrees that landlord shall not first be required to enforce against tenant or any other person, any liability or obligation guaranteed hereby. And then it goes on. Further, it says the undersigned shall not be subrogated to any of the rights of the landlord.
Okay.
And it goes on. It's fairly typical language in a guarantee.
Right.
Okay, so here it says executed first day of January 2016 to be effective the same date as the lease. It says Glenn King DVM. And then he puts the name of the company, but he does not put his position in the company. And according to the case that I've cited, which is Neal v. Tenet Health Systems Hospital, and it's out of the Dallas Appeals Court. That case states on page 606 that Neal's argument was it had to do with a commercial lease. Both his and Wellborn's printed names have MD after their names. He offers no explanation of how being or doctor or using that title shields an individual from liability or suggests any capacity in which a person signs a legal document. And that case is actually on point almost closely with this. But the argument here, Your Honor, is Dr. King knew the difference between being a member of a company. I mean, he clearly he's a professional. He's had a number of different LLCs or corporate or LLCs within the state of Texas. And here he specifically did not sign as a member. And frankly, you know, my client, Narina Properties, Mr. Hashem, who is the managing partner for Narina Properties, owns multiple commercial properties. And he points out in his affidavit that it's his practice to get.
I guess, okay, maybe I've misunderstood this before. So it does seem, so you have one point in the documents where Texas Gulf Coast Veterinarian Specialist PLLC is listed as the guarantor. There's another point in the document where I guess Veterinarian Specialist of North Texas is listed as the guarantor without a signature. And then there's this third point in the documents where Mr. Kingston or Kingdom?
Dr. King.
Dr. King, sorry, Dr. King signs on behalf of veterinary, or it just says his name, Veterinarian Specialist of North Texas. Okay, so maybe this is a little less clear. I understood it was just the Texas Gulf Coast. So I guess, unfortunately, Ms. Mann, you're going to have to respond. You have three different places, three different things that were done where the guarantor is listed. Obviously, this was very messy, whoever did this, but what is your response to that? Why shouldn't there at least be a fact issue about whether or not your client's the guarantor, given the way this is signed here on the screen?
Well, Your Honor, I think that it can be reflected by in the definitional section, which was on the first page where it said Texas Gulf Coast Veterinary Specialist was going to be the guarantor. And it's expressly marked out here on the page that's on the screen right now to show that it's been marked out and is now Veterinary Specialist of North Texas, which Dr. King is just signing on behalf of. And if you'll notice below, it's initialed by the landlord. To me, the landlord has accepted the veterinary specialist of North Texas taking the role of the guarantor. And if opposing counsel could pull the screen back up to
Wait, don't do that yet. I want to ask you about this. So
Okay.
this says Glenn King DVM. I assume that's Doctor of Veterinary Medicine. It's not some initial for member, right?
Yes, Your Honor. He's a veterinary specialist.
And Dr. King is a member of Veterinary Specialist of North Texas. Is that right?
Yes, Your Honor.
And then there's Texas Gulf Coast Veterinarian Specialist PLLC. What does he own that as well?
Not any longer. Dr. King was I believe, a member of Texas Gulf Coast Veterinary Specialist. It was a location in Houston, and they were bought out. He and his current partner, that's part of VS&T and now in Fort Worth, they were
at the time of his lease, though. He was a member.
No, he was not. He was not a member of Texas Gulf Coast, and we have that in our summary judgment evidence. And I think, and this is all on the record, but opposing counsel had sued, or opposing party had sued for a breach of lease agreement of the first lease and of the second lease. And since the filing of our summary judgment, they have amended their petition and taken out the breach of the second lease agreement, because it was not signed either on the signature line of the lease or the signature line of the guarantee. So they have taken that out. But if you look at that second lease, it's really kind of instructive, because they've all the handwriting here is replaced. And so I think that that's some evidence of the intent was for Dr. King, or for veterinary specialist of North Texas, him in his corporate capacity, to be the guarantor. And it just was the
corporation, not the individual, was going to be the
right. And personally, when I first read this, Mr. Jackson and I had to argue about this a little bit, because I was like, but that doesn't kind of make sense to me. But if you look in the lease, because most of the time there is an individual guarantor, it's not the corporate guarantor. Corporate guarantor guaranteeing a corporate lease is kind of unusual, but this lease even has that ability. Just up on a little bit higher on this page, it says, if the undersigned is executing this guarantee for a corporation or other entity. So it even contemplates.
Where does it say that?
It's the very top, is the top
right here. I said, stop. If the undersigned is executing if the undersigned is exercising his guarantee for a corporation or other entity, the undersigned personally represents and warrants that he or she is duly authorized. Is that what you're signing to?
Yes, Your Honor.
I mean, how does that affect this?
I'm just saying that it was anticipated that it would be a corporation guaranteeing the lease.
Well, it says if, right? It doesn't say.
Correct. I understand, but again, I thought it was a little odd that it even contemplated a corporation. And so I'm just saying that it was anticipated that it might be a corporation. It was a corporation. Dr. King signed it on behalf of VS&T. I don't think there's anything in the document, looking at the four corners of the document, that shows anything to the difference. And if you look at the first page opposing counsel showed you, it has a line for title. So of course he just filled in each line. There was a line for his name, then a line for the title, and then VS&T.
I agree with you, Miss Mann. This is a mess. This was not done correctly. Somebody should have proofread it. I'm sure if Miss Edmondson looked at this, she would have made sure that this was done correctly. But it's extremely ambiguous on if he's a guarantor or not. Therefore, there's a fact issue. Therefore, summary judgment's not appropriate. So I don't usually reverse myself in the middle of a hearing, but I misunderstood. I guess I didn't realize there's three different parts. I thought there was just two different parts where this was cited. And you've already dropped the claim involving the second lease, Ms. Edmondson?
Yes, Your Honor, we have.
And I would say this to you is you may decide, oh, I won this. I'm going to go ahead and file a summary judgment on my client's behalf. This is a mess.
Okay, so you're saving me the work. Thank you.
Yeah, it's just, somebody should have proofread this before it was accepted. They obviously didn't. It's completely unclear on who exactly is supposed to be the guarantor. This might be a good chance for you to kind of instruct your client on, hey, look, make sure all of these three things are consistent whenever you have it signed. And do you have an order for me, Ms. Edmondson? Have you?
Yes, I did send an order in for a denial, Your Honor.
Let me make sure I have that. Here, let me see. All right, was there anything else today, guys?
No, Your Honor.
If your client had just put in the word member there, I think this would have been different, unfortunately. But nobody, sometimes it's a lot easier and quicker to get and cheaper to get an attorney involved at this stage. Let's see. Let me make sure I have the proposed order.
I believe she submitted it on Friday, didn't you, Deborah?
Yes, and
Yep,
it was.
we just got it. Yeah, I'll go ahead and print that out.
Right.
Okay, guys, you guys have a safe weekend.
Thank you, Your Honor.
And
You too.
You too.
you guys
Thanks,
be
Your-
safe. Thank you, guys.
Thank you, Your Honor.
All right. We have some more folks here. It's been a busy morning. Let me go ahead and pull your case up. Let me make sure, did I miss was anyone here on the scheduling conference docket? Anyone here on Mousy versus Indemnity Insurance Company of North Texas?
Yes, Your Honor. Randy Johnson here on behalf of the plaintiff, Mr. Mousy.
And Dana Gannon here on behalf of Indemnity Insurance Company of North America.
You guys are here on a continuance motion, is that right?
Yes, sir.
Yes, Judge.
And we're working on it. We're working on this case for purposes of, not having to go through with this.
Okay. Well, you guys are set for trial on the 13th. It's a jury trial. At this point, I don't know if you all saw the order out of the Supreme Court last, I think, Thursday or Friday. They've made it clear that we're not allowed to put cases to trial until we have a jury plan in place. Dallas County does not have a jury plan in place, though we're working on one. There's no way that we're going to have a jury trial on the 13th. The soonest we could possibly have one, I think, would be in November. But so we're going to have to continue it. So when do y'all want me to continue this to?
Judge, I think we may get it resolved, so it may be moot, but if we were going to continue it, I would love to set it in November, December range. I just don't know that it's realistic that we'd get reached for a jury trial then with the changing orders. So, and I've been fighting this battle in my criminal cases, and they're getting set in January and February. So I think January or February might be a reasonable alternative. And in the meantime, hopefully we get it resolved.
Do you want to set on January 5th?
That would be fine, Judge.
Yes, January 5th. Perfect, Judge. Perfect.
All right, we'll go ahead. I think, is that a Tuesday? I think that's
Yes.
a Tuesday. Okay. Let me go ahead and I'll go ahead and print that out and sign it. All right, that'll be at 9 a.m., guys.
Thank you, Judge.
Thank you, Your Honor.
Have a good week. Maybe we be
You too.
excused.
You are excused.
Thank you.
I think we have one more hearing here. Is that correct?
Yes, Your Honor.
Are both sides here on that?
Defense counsel.
Plaintiff's counsel is here, Judge.
All right, this is involving the elevator. Is that right?
Yes.
Yes.
I mean, I understand the frustration here. One of the things that I get complained about from attorneys is I don't like to grant sanctions, and I don't like to grant sanctions, but you know, I am a little concerned about how this all played out. So why don't you guys kind of chat with me and, you know, how can we go forward?
Well, Judge, you know, initially when we scheduled the elevator inspection, I think that Mr. Rios, their position is that they weren't entirely clear what the scope of the inspection would be. I don't know if you've ever conducted an elevator inspection before.
I have.
There's not a whole lot to look at other than the gearbox up top, the elevator itself, and then the elevator shaft. I mean, those are the three components that you would need to inspect to, I guess, do a full inspection and maybe do a ride analysis. So when I had our expert come up, I don't think I specified to Mr. Rios that, hey, we need to inspect the machine room, which is the very top, the elevator, which I think would be, or at least the inside of the cart, and then the shaft as well. It didn't occur to me that I would need to be that specific, because it's my understanding that, at least from the conversations that we had when we were out there on the site, the first site visit or first site inspection, was that management company was not going to let us into the elevator shaft without Bagby Elevator being there, and Bagby Elevator is the elevator servicer. They were not there. I did not know that prior to the inspection, and if I had known that, I would not have had my expert fly up.
When there was communication beforehand about this inspection, did it discuss exactly what was going to be done, or just said it was going to be an inspection?
It was just, we're going to do an inspection.
Is that right, Mr. Henley?
And he's plaintiff's counsel too, Judge.
Yeah, no.
I'm sorry.
Mr. Rios. Yes, Your Honor. And that's why I attached to our response the email chain, because initially when they asked, all they said was, it's going to be inspection. My guy needs 2 hours. And we said, fine. And we made that available to them. They saw the elevator room, they videotaped, took pictures. He rode up and down the elevator with a vibrating caliber to determine the vibration of the elevator. Was there for almost 2 hours. And then he indicated that they needed a key to open the elevator to get into some other areas, which my clients didn't have a key. Only Bagby had a key, the elevator company or maintenance company. My people had initially asked them to come to this inspection to be there, and they didn't.
So Bagby has been added since then to this lawsuit, right?
Yes,
Correct.
Your Honor. And the inspection was then completed with Bagby.
Oh, it was completed. So this isn't, so all we're dealing with is just the sanctions, it sounds like.
Correct.
Yes, Your
I
Honor.
just don't see this as basis for a sanction. I mean, I understand your frustration. I see why you filed it. I'm not saying it's a frivolous motion or anything, but my general view on sanctions is there needs to be some type of pattern of discovery abuse. I don't see that here. I know other judges are more liberal about awarding sanctions. I just am not. That's just my view on things. Did you want to say anything else, Mr. Addison?
Judge, I don't. I know that Mr. Henley might want to chime in on behalf of the plaintiff as well.
Good morning, Judge. How are you?
Good. How are you doing? Good to see you.
Oh, good seeing you. All I can say is we were pretty damn irritated because, writing a check for this, having the guy come up from San Antonio or Central Texas and then, getting yanked around. But I understand your position, Judge.
And I would just say in the future, I mean, both sides, I think this could have all been avoided if Mr. Henley, your guy, had been a little more specific about what was requested. And then Mr. Rios, if you had been a little more, I mean, if either side, I kind of feel like had communicated a little bit better, this probably could have been avoided. Although, who knows, Bagley may not have shown up anyway. Is attorney for Bagley here? Do they have an attorney?
They do have counsel, but I guess they're not here.
Okay.
Yeah.
I don't think they filed an answer yet. Their answer time has not passed yet.
But just, Mr. Rios, I'm not fussing with you, but be aware that I'm giving you the benefit of the doubt this time. But if this keeps happening, then
Yeah, Judge, I promise you, did not know that's my first elevator inspection, so I didn't know the details and what was going to happen They said they needed 2 hours, and we were going to give them as much time as they needed and gave them access to everything we could give them access to.
It's interesting you asked me if I've ever been on one. One of my last cases when I was in private practice, I used to be a plaintiff's lawyer, as Mr. Henley knows, back in the day. And it involved a guy who died on an elevator shaft at the old Texas Stadium, not the big fancy new one, but the old one that was in Irving. And this guy was moving some ice and got pushed into an elevator shaft and died.
Oh.
And so that was one of my last cases I handled. There was all sorts of liability issues with it. And I think Jim Mitchell or Clay Miller, somebody took it over after I left, and I became a judge and ended up settling it. So it was interesting you say that was one of the last things I did as a private attorney was did it. That was my one and only elevator inspection. So it's interesting. We didn't have this issue come up, but I don't blame you guys for filing it. Mr. Rios, just be careful in the future and just try to communicate better. And hopefully this won't happen again.
Will do, Judge.
Thank you, Judge.
All right,
Thank
guys.
you so much for your time, Judge.
No problem. You guys be safe. Good to see you, Mr.
Thank
Henley, Mr. Addis, and Mr. Rios.
All right, take care.
Thank you, Judge.
Good to
Take
see
care.
you guys.
All right,
Stay
bye-bye.
safe.
Okay, let me go off YouTube.